Hi, everybody. I'm Nate Eaton here in the EastIdahoNews.com studios, where we have some news about Lori Vallow Daybell. She wants a new trial. She has filed a 13-page notice, or a 13-page motion, I should say, motion for new trial, and she has a few specific reasons why she feels she should get a new trial. Now, I don't think this is too surprising. In fact, most defendants will file these motions after their trial. Some are more detailed than others. She filed, or her attorneys in Idaho filed a similar motion. Well, I guess they filed a motion for a new trial in Idaho. Similar meaning the reasons were different. But this is kind of her reason for filing this, or her reason why she believes she deserves a new trial. This was filed on Thursday. One is that she says there was juror misconduct. On April 28th, 2025, it came to the attention of this defendant's advisory council and later the court that juror 15 made a statement indicating he had knowledge of this defendant's prior conviction. We have talked about this on Courtroom Insider on East Idaho News, that there was the one juror who spoke with reporters after the trial was done, after they reached a verdict. He came outside and he said this statement to Fox 10 Phoenix.
Yeah. Do you remember your reaction learning that she has been convicted in killing her two children?
You know, I feel sorry for her. You know, I mean, driving home yesterday, I was like, God, she's spending the rest of the next 3 lives in prison in a cell. You know, I mean, you got to feel sorry for her, even though, I mean, that's an awful thing to do. I mean, there's something wrong up here, but what do you think? Still, you know, you just feel awful about it.
And Lori says because of that statement that juror made, she should get a new trial because the jurors were not supposed to know about her prior convictions. So that's one reason. She says there was juror misconduct. Two, she says she deserves a new trial because witnesses, or statements, I should say, by Tylee and Alex Cox were precluded. They weren't allowed in the trial because they are considered hearsay, as Tylee and Alex are not there to take the stand because they are dead. She said prior to trial, the court precluded this defendant from presenting to the jury any of the Tylee Ryan or Alex Cox statements. Both of these people were present during the shooting of Charles Vallow, and thus some of their statements were not hearsay as they show effect on listener pursuant to Arizona rules of evidence. The state filed a motion limine throwing a blanket hearsay objection over the entire statements. Motion limine is basically saying that the state filed this motion as the proceedings were underway, saying all of those statements shouldn't be allowed in because they're all hearsay. The court indicated in a pretrial ruling that it would, at least in Alex's statements, take it on a statement-by-statement basis. During trial, this defendant was precluded from even discussing that Alex conducted a walkthrough, much less his statements with Chandler Police during the walkthrough. Then the state's case in chief, during the state's case in chief, it elicited expert testimony from the scene agent, Detective Daniel Coons. This defendant objected to his testimony as an expert witness. Remember that Lori did not believe that he should be allowed in as an expert based on the lack of foundation and not having time to rebuttal his professional opinion. Again, the defendant was precluded from discussing Alex's walkthrough that was conducted with the police. The walkthrough was precluded as hearsay. However, Detective Coons questioning with the medical examiner and how he then investigated the case as Alex indicated he shot the victim in self-defense. So, bottom line, Lori had an issue with the witness and said she wasn't given enough time to prepare rebuttal because he was an expert, and also had an issue with the fact that Alex's and Tylee's statements weren't allowed in. Reason number 2 why she thinks she deserves a trial. Reason number 3 is because she says there was a discovery violation, that she was not given the code, or the gray key information to Charles Vallow's phone data, the stuff that was on his device. She says she was not given. They could not get into it until April 14th, which was, halfway through the trial. Defense had been requesting this evidence so she could provide it to her independent expert for review. This discovery disclosure occurred in the middle of the trial. Now, the prosecutor said that was handed over to the defense months ago, but the defense couldn't get into it. So Lori's saying, because she's saying the prosecution violated the evidence, the discovery that's the third reason why she deserves a trial. Number 4, she alleges prosecutorial misconduct with Trina K, saying that the state elicited irrelevant, prejudicial, and improper character evidence when Trina asked the Chandler Fire Captain Keller if he overheard any conversations with the defendant. Ms. Trina K asked him on direct examination, "Did you overhear the defendant talking with police?" He responded in the affirmative, saying he overheard someone stating not getting invited to pool party because of the commotion at the house or something. Quote. That was his quote. This statement caught the defendant off guard, as Captain Keller indicated during his interviews with Chandler Police just after this incident occurred that he only saw the male outside on the curb and did not mention even seeing this defendant. So Lori's saying, his witness testimony did not match his police testimony. And that Trina K also during her closing arguments, while addressing the justification defenses, Trina K told the jury that this defendant was not entitled to any of the self-defense instructions. And Lori says that Trina K also commented several times about the defendant's demeanor, that she did not cry during the interview, not knowing there were portions that had been cut from the full interview. That she did show emotion can be seen grabbing a Kleenex. So again, Lori says that there was misconduct from the prosecutor as well as evidence issues, and that's a reason why she deserves a new trial. Again, this whole document's 13 pages long. The fourth reason that she says she deserves a trial is because of the judge, Judge Justin Beresky. She says that the court precluded her from presenting a defense by striking her witnesses, including yours truly, Nate Eaton, and Brandon Boudreau, before we were even called to speak. Specifically, before testimony began, the court required this defendant to establish on the record what relevancy her witnesses would present. This required the defendant to state in front of the prosecutor her defense strategy. This is not required under the law or any rule of evidence. Well, remember, the witness list was filed late after the deadline, and so that was an issue that Trina K raised. Also, the issue as to why I personally would need to be a witness. Lori said it was so that I could impeach other witnesses based on interviews they had given me. Or not interviews, but witnesses that the state had called. Lori claimed I interviewed all of them, which I had not. I had only interviewed, I believe, Adam Cox and Kay Woodcock. She goes on to say, Lori, during cross-examination of Serena Sharp in relation to testimony regarding religious beliefs, the court commented during the prosecutor's objection to relevancy, stating, "I guess to the extent that you're comparing yourself to these biblical figures, I will allow it." Do you remember that? They objected to Lori. She was going down a line of questioning about Nephi and other prophets, and Trina K objected. Part of the state's case was to establish that this defendant had stepped outside of the Mormon religion by claiming she was a translated being, specifically in text messages, saying she would be like Nephi, and that these messages were nothing more than part of a conspiracy to kill Charles Vallow. This defendant attempted to establish that being translated was a regular part of the Mormon religion, and thus a relevant line of questioning. So she has an issue with the way that Judge Beresky stepped in at that moment in the trial. And then she goes on through the rest of the document. I'm not going to go through it all. You can go read it online. She goes on to talk about the specifics about things that Trina K allegedly did, things that the judge did, and why she believes she deserves a second trial and that the first trial should be thrown out. And so she grants or asks that the court grant her a motion for a new trial. Now, undoubtedly, Trina K will respond to this. She hasn't as of now, but this was just filed end of last week. And when that happens, we'll bring that to you. And the judge could hold a hearing or he could not. In Lori Vallow's case in Idaho, I don't believe if the judge did hold a hearing. I think he just rejected it. So all of this is in preparation for about a month from now when we will be in trial for Brandon Boudreau's case. That one begins June 2nd. Jury selection begins the end of May, and we will stay on top of it from now until then. Thanks for watching. I'm Nate Eaton, EastIdahoNews.com.